In a landmark judgment, the Supreme Court today held that delay in deciding the mercy plea is a relevant ground for commuting death sentence to life imprisonment. The court added that prisoners must be given a chance to meet their family members before execution of death sentence. It also added that solitary confinement of a death convict and other prisoners is unconstitutional and legal aid should be provided inside jail to the condemned prisoners. The apex court held that death convicts must be hanged within 14 days after dismissal of mercy petitions. The court said that death convicts and family members must be informed after mercy pleas are rejected by the president or governor.
Well, as far as the death row convicts are concerned, 15 death row convicts had approached the Supreme Court saying or raising the question that there has been a delay in deciding the mercy pleas. In fact, there were 13 death row convicts who, in their cases, there was a delay, inordinate and inexplicable delay of more than 9 years. And in fact, the Supreme Court has attested to the fact that in these 13 cases, there was inexplicable delay. As far as other two death row convicts are concerned, they were cases of mental illness. There were two people, one from Uttarakhand, the other from Karnataka. They were suffering from mental illness, or rather insanity, and there were reports of psychiatrists before the Supreme Court which suggested or testified to the mental condition. The Supreme Court also taking that in view and saying that both these instances, mental illness as well as inordinate delay, inexplicable delay, is a ground for commuting death penalty to life sentence. But what is more important, Arunodaya, at this point in time is that not just delay and insanity is a ground for reducing death penalty, but the Supreme Court has also added 3 more grounds. Number one is solitary confinement, in the sense that the Supreme Court is saying that if a death row convict has been kept in solitary confinement after his conviction, he can approach the Supreme Court for converting his death penalty into life imprisonment, followed by judgment per incurium, in the sense that the judgment delivered by the court is bad in law in itself. On the face of it, it is bad in law. And lastly, the court has also said that if there is a procedural lapse while deciding the mercy plea of a death row convict, it can be a ground for commuting his death penalty.
So this verdict means that sandalwood smuggler Veerappan's aides, who have been on death row since 2004, have been saved from the gallows. The Supreme Court's grants for commuting the sentences, including delay, solitary confinement and procedural lapses. Now, the delay in the cases range from 5 to 13 years, and insanity has also been given as a ground for commuting the sentence to life. Though Khalistan terrorist Davinder Pal Singh Bhullar was not one of the petitioners, this verdict will have an impact on his case, since his plea was dismissed last year on the grounds that a distinction has to be made since he is a terrorist. The verdict will also have an impact on the Rajiv Gandhi assassins case.
Today's judgment is an extraordinary on that post-conviction mercy petition and delay. It's a very extraordinary judgment today, but it will squarely apply to Rajiv Gandhi assassination case, because the ground delay is Rajiv Gandhi assassination case boys are more than 11 years, 6 months delay are there. So here today's judgment is clearly on undue, unreasonable delay want to be commuted. If the government has not prepared to explain or not in the position to explain this delay, we want to, it used to be commuted, is the only question on delay. So Rajiv Gandhi boys will be open to appear plea before the court on the delay part itself, and they are very sure they will be commuted as a life prisoner.
With due respect to the mistaken distinction that was drawn in Bhullar's case, the implications of this distinction are that you can torture a terrorist. Now, torture, of course, is prohibited by Indian law, but Bhullar's case implies that you can torture a terrorist, and it is on that distinction that Bhullar was denied the benefit of the delay. The court has rightly said that that is not a valid distinction. Yeah, it's very difficult.
Just one statement, very complete one question.
Give me a question.
तो सुप्रीम कोर्ट में क्या कुछ हुआ है?
आज सुप्रीम कोर्ट ने 15 के 15 कैदी जिनको सजाए मौत दी गई थी काफी साल पहले, उनके ये सजा जो है इसको तब्दील करके उम्र कैद की सजा कर दी है। इसका कारण ये है कि गवर्नमेंट ने उनका मर्सी पिटिशन बहुत देरी से फैसला किया और कई रेलेवेंट फैक्टर्स जो थे जिनको जिस पे गवर्नमेंट को गौर करना चाहिए था उसको नहीं किया, गवर्नमेंट पे उस पर ध्यान नहीं दिया। और ये कारण है कि सुप्रीम कोर्ट ने कहा है कि इन सब कैदियों के सजा जो है इसको उम्र कैद में तब्दील की जाएगी। ये जो फैसला है सुप्रीम कोर्ट का आज, ये साफ जाहिर करता है कि हर आदमी, हर व्यक्ति, कैदी हो या कोई भी हो, उसकी राइट्स हैं और ये राइट्स अंतिम दम तक उसमें हैं और कोर्ट्स उस राइट्स की रक्षा करेगी।
तो कुछ गाइडलाइंस भी कोर्ट ने फ्रेम की हैं।
ये गाइडलाइंस जो हैं गवर्नमेंट के लिए हैं। ये कहती हैं, ये दिखाती हैं, साफ दिखाती हैं कि मर्सी पिटिशन कैसे डिस्पोज किया जाएगा और उसके बाद क्या किया जाएगा। सुप्रीम कोर्ट ने यह भी कहा है कि कैदी और उसके फैमिली को जब तक 15 दिन की नोटिस ना दिया जाए, 14 दिन का नोटिस, उसकी फांसी नहीं हो सकती है। ये दिखाता है कि जो हमने अफजल और कसब के साथ किया, जिस तरीके से हमने उनकी हत्या की, ये गैर कानूनी था।